This is the mistake that costs Colorado parents real money after a divorce. It has to do with child support. Your life changes, your parenting hours change, your ex get a raise, your schedule shifts, and you assume the child support number is going to change along with it because you and your ex agree to it. Well, it does not. And in Colorado, the order that you have is what you owe until the court enters a new one. Every dollar. So if you just start paying less because you think you should or because your ex kind of voluntarily agrees, you are not changing your order. You are falling behind on it. And those missed payments, they become arrears and they do not go away. If your situation has changed, the answer is to ask the court to modify your child support order, not to change what you pay on your own, not to change what you pay by agreement. You lost your job, so your child support drops automatically, right? Wrong. In Colorado, your order stays in force until a court changes it. The payment does not change the day your income does either. You have to ask the court. And how you lost the income matters. A layoff, a closure, a health crisis. That is the kind of change the court will address and can modify based on. Walking away from a good job for the purpose of changing child support is not a good reason and not a reason to explain to the court as to why you need to modify support. But here's the part that can cost people. A reduction only reaches back to the day that you file, not to the day you lost your job in most cases. So every month you wait to file is a month you do not get back. If your income dropped, do not wait. Did your co-parent's income increase since child support was ordered? That number might be due for a look. In Colorado, a real lasting increase in the other parent's income supports a higher order. And income is broader than salary. It includes bonuses, commissions, contract work. The things that don't show up on a simple pay stub, they all can count. A one-time bonus may not count. A new salary that becomes the baseline, that usually counts. When it comes to changing child support in Colorado, timing is money. Let me explain. When a court changes your support order, the new child support number reaches back only to the day you filed, not to the day your life actually changed, except in specific limited circumstances. But for the most part, if your income dropped in January and you file in October, the months in between are gone. You do not get them back. And it runs both ways. If you are owed more, waiting to file means money you are not collecting. If you should be paying less, waiting means money you are overpaying. The move is the same either way. When a real change happens, file for modification of child support instead of waiting. Let's clear up what does not change child support in Colorado, because acting on these costs people money. A child turning 18 does not end child support. In Colorado, support runs till age 19, and even then, only for the last child. A kid heading to college does not create a tuition obligation unless it was part of the original court order. A teenager picking up a part-time job usually isn't going to move it. One rough month does not always count because the change has to be lasting. And a handshake deal with your ex, which is my favorite, where you agree to pay less for a while or they agree to let themselves pay less for a while, it doesn't replace a court order. If the court never made the order, you still owe the original amount and the gap becomes arrears. If your life has changed since child support was set, you have probably asked yourself one question. Can child support actually be changed now? Well, in Colorado, the answer is yes, but not the way most people think. So let's walk through how it really works. Start with one rule that governs it all. To change a Colorado child support order, you need a change in circumstances that is substantial and continuing. And substantial has an actual test. If you run the numbers again with today's facts and the result is at least 10% different from your current order, that counts as substantial. If you run your child support with today's facts and it doesn't move the needle 10% either way, that is not substantial. Now, continuing matters just as much. A change that is real but temporary, like a slow month or a one-time bonus, that is not substantial. The court is typically looking for a change that is going to last. Now, the part that costs people real money, so stay with me, is that when your order is in full force and effect, it remains that way until a court changes it. Your income dropping does not lower it. Your ex's raise does not raise it. Until a judge enters a new order, the existing one is what is owed, and that is every dollar. So if you just start paying less on your own, you are not modifying your order, you are falling behind on it, and that turns into arrears. And here's the timing piece. When the court does change the support order, it reaches back only to the day you filed, not to the day your life changed, except in a limited circumstance. So waiting to file is money you do not get back. What actually lowers child support? Losing income can if the loss was involuntary, like a layoff or a health crisis, and if how you lost it holds up to the court when you go to explain it. A real increase in your parenting time can modify child support, especially under the 2026 rules that credit overnights differently. And when a child ages out, they become 19, but you still have younger kids, that can lower it too, but only if you file to recalculate, because it does not drop on its own. What raises it? A real lasting jump in the other parent's income. New ongoing medical or special needs for your child raises it. Childcare starting or cost climbing, or a parent's income growing through a business or career move. Now, a few things people assume change support but do not. A child turning 18 does not end it. In Colorado, child support runs to 19 unless there are exceptions. College does not create a tuition obligation unless there is an original court order based on an agreement of the parents. A teenager's part-time job won't move the number, and an informal deal between your ex and yourself does not change or replace child support. If a court never entered it, the original order still controls. Just think of it that way. And all of this comes down to one thing. Every real change has to go through the court, and the order you have will remain in place until that happens. The law does give you a path when life genuinely changes. It just asks you to use the court path of modification instead of deciding to change it on your own. So if something real is shifted, do not wait and hope for the number to catch up to your real life. Find out quickly whether you qualify, and if you do, let's file. We help Denver and Colorado parents do exactly that. There's a link below for a free consultation and a link to our full article on changing a child support order. We choose sides. Yours.